This microtalk is part of a mini-series on intellectual property ownership. We encourage you to watch the entire mini-series available on Springboard. Thank you.
Now let's briefly talk about patents. Patent rights originally belonged to the inventors, meaning the individuals who conceived of the invention. So companies can own patents only by assignment, whether or not they paid for the development. Now, US courts sometimes do give effect to an implied assignment of patent rights in situations where a person was very clearly hired to invent. For example, the person's job description is to find a novel solution to some technical problem, but proving that a person is hired to invent is typically not easy. So if you want to own patent rights as a company, you should always get a written assignment of those rights from the inventors. That brings us to the nuts and bolts of an effective IP assignment. The words of the contract do matter. All too often I run into employee agreements or other contracts that simply say that the IP being developed shall be owned by the company, or that the other party shall assign or agrees to assign the intellectual property rights to the company. And courts have held that those kinds of phrases are not enough to give the company legal ownership of the IP. A phrase like "you agree to assign" may obligate the person to assign the IP in the future by signing some future document, or at best it could give the company equitable title, allowing it to practice the IP, but that's not enough to stop others from infringing the IP. To truly control and enforce the IP as its owner, you need to hold legal title. The best words to accomplish that are, "the other party hereby assigns to the company," indicating a present tense transfer of the IP rights. And that's true even if the IP doesn't yet exist. In that case, if and when the IP is created, the company automatically receives legal title to the IP because the creator has prospectively assigned it over. And that approach is usually much better than waiting until the IP exists and only then seeking an assignment. One other point related to getting patent rights or invention rights from your employees. Several states like California, Illinois, Utah, and Washington have statutes saying that an employer can't make employees, as a term of their employment, assign rights in inventions that they make off the job without using the employer's resources that don't relate to the employer's business. So employee invention assignment agreements should be drafted to stay within the bounds of any relevant state statutes. And if the company wants to own some invention that's outside of those bounds, which may be the case, for example, when you're dealing with founder's IP, the purchase and transfer of that IP may need to be supported by separately negotiated compensation. To learn more about IP and other topics of interest to startups and their investors, I invite you to visit Mayor Brown's Emerging Companies and Venture Capital portal, Springboard. And thank you for listening.